So the the IDEA, that stands for Individuals with Disabilities Education Act, and it's a federal law. It's a pretty complex law, to say that I've been practicing it for 27 years means that I haven't perfected it yet. I'm still practicing, still trying to understand all of the nuances of it. Give you a quick primer on the law for those of you who may not know this, because these are things I didn't know before I went to law school. We have two different court systems in our country: the state court system and the federal court system. And so there are federal laws and there are state laws. The IDEA is a federal law, and then Maryland has regulations to implement the federal law. Any state all states have to follow the federal law. And so they have to create their own regulations so that they're implementing that law. So Maryland, the Maryland laws would fall under what's called COMAR, which is an acronym, and it's Code of Maryland Regulations. So if you are in IEP meetings and you hear somebody say COMAR, that's what they're referring to, is the Maryland regulations that are designed to implement the IDEA. State regulations can provide more services, more protections than the federal, but they can't do less. So for example, here in Maryland, the age at which you can continue to receive special education services is up through the year in which you turn age 21, the school year in which you turn age 21. So if you turn 21 in September, you get to go to school until June. If you turn 21 in July, you're done you don't get to go another year. Michigan, they go, adults, they can continue in school until age 26. So that they extended their law. So like I say, you can do more than what the federal law requires, but not less. So the handouts that you have there, what you don't know, basically I decided to say, well, let's tell you what you should know. These are the things that you really should know. And there's a number of things, and probably the first one on that list you probably already know, at least I hope you do if you're involved in special education and you've been to IEP meetings. That IEP really is the most important document in your child's file. Yes, evaluations like a psychological or an educational or a speech language or OT or whatever, even a functional behavioral assessment, they're all important documents, but they're tools for creating the IEP. Because the IEP has been equated at times with a contract. It's not a contract. Courts say, no, it's not a contract. But it's a lot like a contract. And the reason they say it's like a contract is because you have two parties, parents and school. And the parties are supposed to come together, reach an agreement on something, put it in writing, like you would a contract, and then both parties are supposed to follow that contract. Now, most of the duty, responsibility, accountability is on the school system. Your duty as parents is to get your child to school. Their duty is once he's there, is to him or her, is to make sure that your child is getting the services that are outlined on that IEP. If it's not in the IEP, then they don't have to do it. The school doesn't have to do it. So you hold the school accountable through the IEP. So that's why it's so important when you're sitting in an IEP meeting. Have all of you been to IEP meetings? How many of you are, okay? So when you're sitting in an IEP meeting, it's why it's so important to just keep fighting for every little thing you can get into that IEP, because if it's not in the IEP, they don't have to do it. There have been cases where school personnel have said, oh yeah, we're gonna do this, we're gonna do this, we're gonna do this, but it didn't make it into the IEP. And so when parents, and there was even a case here in Maryland that went to the Fourth Circuit Court of Appeals, which is a fairly high court, it's one step below the Supreme Court, and it went up and the parents said, but the school system told me, and this was Montgomery County, the school system told me that they were agreeing to my child's placement in this residential school. It wasn't in the IEP. The IEP didn't say that. They lost. Didn't matter. They could have had a recording of it. They could have had affidavits from everybody who sat at that IEP meeting and said, yeah, we all agreed to this, but didn't go in the IEP. And you know what? They'd still lose on that, most likely. That might be a little bit extreme, because there's also a requirement when you go to IEP meetings on both parties, the school as well as parents, to act in good faith, which means you shouldn't be lying. So you shouldn't say, oh yeah, we're going to do something. The school system shouldn't say, we'll do something and then not do it. They shouldn't say, oh no, we don't need to put this in the IEP, because we just do this automatic. That would be a lie if they didn't. So that might be a reason for parents to prevail on that. But I just emphasize that the IEP is really the most important document in your child's file. And feel free to ask questions as we go along here, because we've got a couple hours, and I created this so there'd be plenty of time for questions. So those of you who have been to IEP meetings, how many of you felt like you were equal members of that IEP team? You do? Okay. Well, that's unique. Is it here in Harford County? Very good, very good. Okay, in Harford County? Okay, but your Harford County is where you live. Yeah. Okay, and he goes to Kenny Krieger. Very good. All right. It doesn't often happen. I mean, usually when I give this presentation, I ask that question.
It wasn't easy.
What's that?
It wasn't easy.
Yeah, it never is. But it's rare that anyone raises their hand. So to even get one hand raised, is unique. But the law really emphasizes parent involvement. I mean, when in your handout, I noted some things where there are provisions in the statute. When I say the statute, I'm talking about the federal law, IDEA, in the statute, where it really places an incredible burden on school systems, which I don't think do very often. But for example, what I have written in there, before they can hold an IEP meeting, a school system or a school can hold an IEP meeting without the parents, they have to have detailed records stating that they tried to get you to come, they called you, they sent you letters, they sent you emails, they even came to your house or your place of employment to say, we really need you here before they hold that IEP meeting without you. Now, I've seen plenty of situations where they've held IEP meetings. They send a parent out a notice, they have the IEP meeting, and the parent doesn't show up, say, well, we gave you notice. That's not good enough. That really isn't. And you're looking at me like, gee, that's happened to me. Has that happened to you guys?
And I've had parents say, well, I didn't know what to do because they called me and said, can you come be here at 8:15 tomorrow morning? And they're like, well, sure, because they didn't.
Well, in Maryland, so the federal law says, and here's something where Maryland's a little better than the federal law. The federal law says that they have to give parents enough notice so they can attend. Maryland law is clear about that. No less than 10 business days. I'm sorry, no less than 10 calendar days notice. Really? Okay? Yeah. Maryland law.
They only give you like 3 or 4 days.
No, then they're breaking the law. But if you show up, it's like no harm, no foul, because you're there.
I always show up.
And you show
you
up
don't?
because you don't
Okay.
know what, you kind of.
Yeah. Well, the law says that the IEP meeting, and you'll love this, the IEP meeting is supposed to be at a mutually agreed upon, you and the school, agreed upon time, date, and place. So if they ever say to you, we're going to have the IEP meeting on this date at this time in this school, you can say, how about if we have the IEP meeting on this date, this time, and at my office or at my home?
I'd like that.
Yeah. Do that sometime. See what happens. Now, I will tell you, I have never gotten a school system to hold an IEP meeting in a different location. I don't fight it too much, but I know other attorneys who have, not in this state, but other places. They told me, at least they tell me they have. Never know. Attorneys, you got to watch what they say. Anyhow, that's what the law says. The law says mutually agreed upon, and at the very least, the date and the time. So if you, and I know schools all the time send out notices and saying, we're holding the IEP meeting on this date and this time. One of the things I have in here is putting things in writing. You respond to that and you say, sorry, I'm not available that date, that time, and offer some other date or time, or maybe a couple of dates. I do that all the time. when you're a lawyer, they're not going to mess with you. They're not going to say, oh no, it's this date, this time, or else, we'll have it without you. They would never say that to me or any of my clients. They're going to say it to people who don't know otherwise. So if they're telling you that, you just say, no, we're not going to do it that date. They call you up and say, we're going to have the meeting tomorrow at 8:15. Sorry, that doesn't work for me. We'll have it another date, another time. Send them an email. You want to document that you said, no, this is not a convenient date, not a convenient time. The law is very clear about it being mutually agreed upon. And then beyond that, as I talked about, before they can even hold that IEP meeting without you, without parents, they have to have these detailed records. And that's what the law says. I'm not making that up. That's right in the statute. Detailed records of their attempts to reach you by phone, by email, by letter, or you're coming to your house, your place of employment, to encourage you to come to that IEP meeting. So if they hold an IEP meeting, if they were to say to you, we're holding the IEP meeting on a date, even if they gave you 10 days notice, if you told them that date didn't work for you and they went ahead and held that IEP meeting without you, that would be a significant violation of the law. Okay, and we'll come back to what that gets you when they make those mistakes. So as I said, or alluded to earlier, written communication is better than verbal communication. In your printout there, I mentioned Pete Wright. How many of you know Pete Wright or know who Pete Wright is? Okay, Pete Wright is an attorney who he doesn't really practice anymore, but he gives lots and lots of presentations. He travels all over the country giving presentations. He's in Maryland periodically. He had a case back in 1992 before the Supreme Court where he won a unanimous decision, which is rare in the Supreme Court. And since that time, and he continued to practice for a while, but since that time, he's developed this really great website, and it's free access to the website, and there's tons of information on it. So if you're not familiar with the website Wright's Law, which is spelled WRIGHTSLAW, wrightslaw.com, that's a great resource. And like I say, it's free. Now there's stuff on there that he sells, like books and other things, but there's tons and tons of information on there. I don't know how he keeps up with it all, but lots of information on there, and it's very, very helpful. So I highly recommend going to that website and checking it out. It'll take you days and weeks and months to navigate the whole thing because there's so much information on it, but it's very helpful. Anyhow, Pete, who I work with also, one of his favorite sayings is that a verbal contract isn't worth the paper it's written on. If it's said, but not written, then it was never said. So parents come to me all the time. My clients come in. They say, "The teacher said this." I said, "Did she put it in writing?" No. I said, "Then she didn't say it." No. She really told me that. Doesn't matter. She didn't say it. I mean, if it's something that's going to go against the interests of the school system, it is highly, highly likely that teacher is later on going to deny they ever said it. I've had it happen multiple times. And I've had them say under oath that they did not say what they said to the parent. I mean, it happens all the time. Now, how do you deal with that? Do you have a question?
Yeah, are the schools resistant because everything comes down to money?
Yes.
Okay. I mean, you would think that in that profession, your idea would be, I'm here to educate and teach and
Yeah.
But everything does come down to money.
Well, you know whose fault it really is? It's ours. It's our fault. Why? Well, we're all voters, right? Who do we vote for? The people who we vote for, our county council, county executive, they approve the budget for the school system, irrespective of where you are, whether you're in Harford County or Baltimore City or wherever. The voters are voting for people who are saying, I'm going to keep your taxes down. Vote for me, I'll keep your taxes down. Well, how they keep their taxes? You keep your taxes down. They cut services. And one of the places where they cut services is in education. And so it all comes down to this. The Board of Education, they submit their budget to the county council. The county council either approves it or doesn't. the Board of Education has, I think if you've been following the newspapers, you know, Hartford County is getting significant cuts to their budget this year. And they're they're in debt, Hartford County schools. So they start cutting things. So, you know, I mean, I'm not saying that we should all go out and vote for the person who says, I'm going to raise taxes or, you know, have the highest taxes. I'm just saying that we need to accept responsibility. That, you know, when the Board of Education's budget gets cut by the county council, and when the Board of Education then has to operate within that budget, and when they then say to the superintendent, here's your budget, you got to operate within it. And then he tells his assistants, and they tell their assistants, and it trickles down to the schools. And then the principals are told, look, we only have a limited budget for this, so you can't approve any more services than this. And the principal says to the teachers and the other people working in the school, you know, don't tell parents that they might be entitled to X, Y, and Z. Or if they come to you and ask for it, say, no, your child doesn't need it. Now, why would they say your child doesn't need it? Why don't they just say we can't afford it? Our budget got cut. We don't have the funds for it. Anybody know why? Why? Exactly. Federal law doesn't allow them to say no because of monetary reasons. If a child needs something, if a child needs speech therapy 10 times a week in order to receive an appropriate education, the child should be able to get that. The child's supposed to get that. If a child needs a full-time nurse to be with them one-to-one, that costs $60,000 a year for that one child. They have to provide it. If a child needs to go to Kennedy Krieger, which Kennedy Krieger, depending on what program you're in, can cost anywhere from $80,000 to over $100,000 a year, the school system has to provide it. Now, that's not that serious a problem. The money is always an issue, but individual things like that, you know, school systems are never going to say they can't afford it around here. You know, we have big school systems, big budgets. There are some school systems out in the Midwest, and I mentioned the nurse, the $60,000 a year nurse, because the school system said, we can't do that because that school system out in the Midwest consisted of 2 schools. That was the whole school system. And they didn't have a budget for $60,000 for a nurse. And it went all the way to Supreme Court. Somehow they had the budget to pay for the attorneys to go to the Supreme Court. I'm not sure why that was, but you know, they couldn't pay for the nurse, and the Supreme Court ruled against them and said, no, you got to provide the nurse. It's clear the child needs it. Everybody agrees the child needs it. Just because it's too expensive doesn't mean you're allowed not to do it. They have to do it. So it does come down to the money. And teachers are in, I think, a terrible bind at times. Because they are being told by their superiors that, frankly, they have to tell parents, no, your child doesn't really need this, when they may think their child does need it. And I did a presentation a little while ago, maybe a couple years ago actually, where it was a panel of us, 4 attorneys. 2 were school system attorneys, 2 were parent side attorneys like me, and I was one other. And most of the people in the room, actually all the people in the room, were school personnel. And what was really interesting about it was that they had teachers and you had administrators. And there was like an aisle down the middle of the room. And there was a big group over here, and these were all the teachers, and there was a big group over here, and these were all the administrators. And there was a part of the program where we were supposed to talk about professional ethics. And I, led that discussion. And instead of talking about ethics is something that you don't want to lecture people on, you want to have a discussion about. And so the first question I said to them, well, tell me what questions you have. What are your ethical concerns? And a teacher raised her hand. She says, my concern is that my principal tells me that I can't tell the parents when I see their child has a need and should be in special education. I'm not allowed to tell the parent that that the child should be tested or the child might need these services. And I said, okay, how many other people have run into the same issue? And every hand went up on the teacher side. And the administrators are sitting over here, they're just glaring at the teachers. How dare you tell this parent side attorney that, our secret. It wasn't much of a secret, but yeah. But that's the reality. Go ahead.
Question.
Uh-huh.
So,
So the question for anybody who didn't hear it is that if you have somebody who's a long-term substitute because the special education teacher left or went out on medical leave or whatever it was, does that qualify in terms of implementing the IEP? The answer is no. And I had a case like that a few years ago where the special education teacher, I don't know, she left like in October or something. I don't know. I don't remember why. And they had a substitute the whole rest of the year, and they tried to say, and this was in Montgomery County, and they tried to say that, well, that substitute was closely supervised by the special education department chair, and so that was good enough. We filed a complaint with the State Department of Education, a state complaint. And that's a pretty inexpensive way, an easy way to challenge a school when they make a decision like this. Because people think, oh, you need a lawyer anytime you want to go up against the school system, but you don't. Anyone in here could file a state complaint. Has anybody filed a state complaint in here? Okay, Sue has. Flossie has. Okay. And did you need a lawyer to do it? You did it without a lawyer, so good. Not that I'm trying to drive away business, but but you really don't need a lawyer for that.
I'm going to say MSD helped us do it.
Okay, good. Because really, and I'm going to come back to your question, but I don't want to go too far off on a tangent. But I just want you to know there are other ways of advocating without having to incur the expense of an attorney, a private attorney. And basically, MSDE does have a form for filing a state complaint, and you can file a state complaint anytime you feel that the school system is not properly implementing your child's IEP. Now, if you file a state complaint saying that you feel that the IEP is not appropriate, the state's not going to really do much with that because they're going to say that's an IEP team decision, and we don't look over the shoulder of the school system regarding those kinds of decisions. But if they're not following the IEP, which is your situation, they had someone who was not qualified to be teaching the child, and the IEP, Section 5 of the IEP, where it says services, it identifies who are the people responsible for providing the service, and it's going to be listed right there, first and foremost, special education teacher. That person's not a special education teacher, that IEP is not being followed. And that's what the state looks at. If it's that, usually they're looking at procedural violations. That's both procedure and substantive because the IEP is not being implemented. Yeah, basically what the courts have said about that is that, and it's a little crazy, but the courts have basically said as long as the special education teacher is in the room, and frankly I think she could probably be sleeping in the room and the courts would still be okay with that. They're saying, well, the child is receiving special education instruction. I'm exaggerating. I don't think if the teacher was sleeping, they really say that. But the courts get a little ridiculous with this because they say, well, that teacher's in the room, so we're going to assume that that teacher is teaching, and that paraeducator is working under the guidance of the special education teacher, which is permitted. Okay, so what really is the issue here is not who's doing it. It's that your child, is it your daughter, that your daughter is not making progress. Okay. So now here's where the IEP comes back into play. This is why I keep saying the IEP is the most important document. One of the things that I do, and that is the kind of trick of the trade, if you will, it's not anything tricky about it, but you look at the IEPs, okay? Now, the IEP in Maryland is divided into 6 sections. Section 1 is just general information, your names, your address, your child's name, what the child's primary disability is, just basic information where there's been meetings and that kind of thing. The second section, this is the section you want to pay attention to, is called present levels of academic achievement and functional performance. Present levels of academic achievement and functional performance. It's section 2 of the IEP. And every IEP in Maryland has the same section 2, okay? And what you do is you take the IEPs from the previous years, so go back to first grade or even kindergarten, to second grade, to third grade, to fourth grade, to fifth grade, wherever your child is now, and compare. Because they're going to say, this is where your child was functioning back when she was in the first grade, when she was in the second grade, when she was in the third grade. I have seen IEPs where they say the child has been working at the same grade level for 3 or 4 consecutive years, even though they've said the child's made progress. Well, how is that progress if you're at the same grade level? Now, even if the grade level goes up a little bit, you have to look at, there's a narrative section that explains what your child's doing. And you have to, sometimes it's hard to figure out, okay, is this actually an improvement from this? It can be a little tough. And sometimes you may need some help with that. Educational consultants or maybe people at the ARC can help you understand that a little bit better. Because I tell you, it's a challenge for me at times when I read these to say, is this progress or not? I don't know. The other thing you can do is look at the goals on the IEP. And if you have the same, that's section 4 of the IEP, or the goals. And you may see that your child was making progress in this reading goal all year long last year, but she has the same goal this year. Well, how do you make progress year after year after year, quarter after quarter after quarter, and still have the same reading goal, the subsequent year? I was looking at an IEP just yesterday, and on the IEP, and this is a Harford County IEP, it says that when you get your IEPs and you look at the progress reports, it almost always says making sufficient progress to meet goal. That is a default statement. Okay, it's just there. The only way it gets changed is if the school changes it. Okay, somebody has to change it. So it's an automatic. You always see it. Making sufficient progress to meet the goal. In this case, this was a child who had who was on the autism spectrum and had some self-injurious behaviors. She would hit herself in the head. Okay, and so they were keeping good data on it. So the baseline where she was in the present levels, they said, well, her baseline at the start of this was she was doing it 17 times a day, hitting herself in the head 17 times a day. I looked at the progress report, and he said, well, she's making, and the goal was to reduce that to, I think, 12 times a day, try and get it down to 12 times a day. So I looked at the progress report, and the progress report said she's making sufficient progress to achieve this goal. She is currently hitting herself in the head 89 times a day. How is that progress? But that default of making sufficient progress, just whoever filled that out, teacher, behavior person, didn't even look at it. They just wrote, yeah, she's hitting herself in the head more, so this is something we need to be working on. But it's not progress, So you got to look beyond that default, making progress, and read what they actually write in there. So it's rather interesting sometimes. Okay. With regard to, I'm talking about written communication. And just to get back to what I was saying, if you have the same goal year after year after year, and I've had that happen too. I represented a child on the Eastern Shore a few years ago who was in the 9th grade, and she had the same goal, reading goal, since she was in the 3rd grade. And yet they said that she was making progress and that she was doing fine, and what they were doing was appropriate for her.
Question.
Yeah, go ahead.
So beyond academics, you can have stuff in there as goals or goals.
Well, remember what I said that second section of the IEP says?
Okay.
Present levels of academic achievement and functional performance. Functional performance can be toilet training, self-care skills, dressing, zippers. It can be behavior. It can be social skills. It can be peer interactions. It can be anything. Yeah. Yeah, making progress doesn't mean that she's perfected it,
Right.
So, here's when the IDEA was first passed, had a different name. It was Education of All Handicapped Children Act. When it was first passed, and even when it's been amended over the years, it's always had this same identified purpose: to ensure that children with disabilities receive a free, appropriate public education. I'm going to come to that in a minute. That will allow them to achieve employment, independent living, and further education. So if your child's IEP is not helping your child move towards those goals, that's the purpose, then your child's IEP is falling short. It's not adequate. So you can always go and say, okay, my child needs this in order to be able to live independently, achieve employment. And look, if anybody ever says to you, well, you know, your child's never going to be independent or have employment, you know, I can't say in mixed company how I respond to that, but I think you need to say to them, you're in the wrong profession, because if you think that, you know, that you can't help my child move towards that goal, then you should be going somewhere else, you know, flipping burgers at McDonald's, do something, but you're not helping children when you have that attitude. Yeah, so, you know, those are the questions you can ask your IEP team. How is this helping my child become independent? How will this lead to my child achieving employment or further education? Okay? Sure. All right, so written communication, I already talked a little bit about that, but I just want to emphasize that if the school calls you, someone calls you, or if you're at school and someone pulls you aside and says something to you, and you think that that's something really important, you can follow up with an email, a letter, whatever. I like email, yourself to that person. So let's just say hypothetically, Miss Smith says to you, you know, I'm really concerned about your child. He's not making progress. You know, and I'm just telling you this off the record. I mean, in the IEP meeting, I can't really say this. And, but I want you to know I'm doing the best I can. They sound real friendly, they sound real nice, they sound like they're trying to be on your side. But if they're not going to stand up for your child in that IEP meeting, they're not really your friend, you know, they're your enemy, because they're just kind of appeasing their guilt in some respects. My suggestion, anytime someone says something to you that you think is important, if they didn't put it in writing, they just said it, follow up with an email to them. Say, dear Ms. Smith, thank you so much for talking to me today. I really appreciated what you had to say, even though it was hard to hear. You know, I'm concerned. I'm just as concerned as you are. You know, if Johnny's not making progress in your class, if Johnny's having all these behavioral issues in your class, if Johnny is, you know, just not learning in your class. I mean, whatever that person said to you, follow up with an email, a nice email. You don't want to put it in terms of what a lawyer might write. You know, I'm writing this to verify that you said this on this date at this time, and therefore I'm holding you to it. Because you're going to get a response saying, I never said that, forget it. Something friendly, you know, and they don't deny it. They may still deny it, but, you know, chances are they won't under those circumstances. And now you have documentation. I had a client one time who, her child was finishing elementary school and getting ready to go to the middle school. They didn't want the child to go to the middle school because they just didn't think it was an appropriate placement, and they were seeking a private placement. Well, at the IEP meeting, someone from the middle school had participated in the meeting and sat through the meeting and just listened to what they had to say about the child. And after the meeting, the person from the middle school said, your child really should not come to our middle school. This is not the right placement for your child, and you should continue to fight to keep your child, you know, out of this school. You know, wherever you want to go someplace else, but it's not going to work here. So my client, I wasn't at the IEP meeting, but my client sent me an email telling me what happened at the meeting and said, oh, by the way, something weird happened after the IEP meeting. This person came up to me and said this. Well, here's the other thing too. When somebody says something to you like that's really helpful to your child, send that email quickly, you know, because what you have are what you call a contemporaneous record, okay? The record, you're writing it down as close to when the event happened as possible, because it's more likely that you remember it more accurately when you write it right after it happened, right?
Yes.
You know, I don't know if anybody's read James Comey's book, you know, on, you know, leadership, but he was talking about in his book how every time he had a meeting with the president, he would immediately go back to his office and write down everything that was said because he knew things weren't going to work out and he wanted to have a record. So it was very, very compelling. Anyhow, this parent, right after the meeting sends me this email, and the school system wouldn't agree to the private placement. We ended up going to a due process hearing. A due process hearing is basically a trial, before an administrative law judge. You put on your evidence, witnesses, documents. They put on their evidence, witnesses, and documents. And the person who made that statement, it was a teacher from the middle school, on the witness stand said, "No, I never said that. I never said anything like that." Well, we had the email. I had the email from my client saying, what had been said. And the judge, in her decision, said, "It is clear to me that that person was lying, because this email was written right after the IEP meeting, and it was just a contemporaneous record of what happened. And for this person now to say she never said it, judge didn't believe her." So those kind of things help. Having things in writing makes a big difference.
Is that why, like, where we're at, the paraprofessionals say stuff to parents, but it is quite clear through the school that they are not allowed to attend any IEP meetings.
Yeah.
And they're the ones that have the direct relationship with the kids.
What I recommend about that, again, put it in writing. Request that para-educator come to the meeting. Now, they'll say no. And every IEP meeting, you keep asking, couldn't the para-educator? You keep asking over and over because you have a record of requesting it. Because if you run into a situation where there's going to be, whether it's a legal proceeding, or you file a state complaint or something, and I've never heard the state weigh in on this, whether or not, when a parent asks for a para-educator to be there, the school can say no. The law says that you're allowed to bring anybody to the IEP that you want.
Bring anyone you want, so why
Yeah.
wouldn't the parent be able to bring, maybe if they weren't working?
Yeah. Yeah. I mean, I guess the school's argument is that, well, they work for us, and they have duties and responsibilities, and pulling them away from those duties and responsibilities, we can't do. Then you say, okay, let's have it after school. We'll meet after school. Yeah. We'll meet on Saturday. Let's do it on Saturday. Mutually agreed upon place, time. Go ahead. Yeah. Unfortunately, that's retention, anything like that. That's not an IEP team decision. It's not part of the IEP. The grade, that's a different process. So I think what they're telling you is unfortunately accurate. But what I will say about that is that so if they're moving a child from elementary to middle school, and that middle school is not appropriate, well, then that's an IEP team, issue, and they need to determine what are you going to do about that. Are we going to try a different middle school? Are we going to try a different program? Are we going to incorporate more resources into the IEP? Yeah. So what happens a lot, and I'm sure any of you who have been through having a child move from elementary to middle recognize, is that schools a lot of times will write the IEP, redo the IEP, because the way things work in elementary school are different than middle school. So if this child was in a self-contained, in one class throughout the day in elementary school, and transitions are difficult for that child, and being in the same class throughout the day with the same teacher was beneficial for the child, then you try and get that into the IEP. Now that would be in the section under supplementary aids and services. That's section 3 of the IEP. And the supplementary aids and services section of the IEP, it's kind of like, I refer to it as kind of the Wild West, because you can put anything in there. You can try to put anything in there. School systems fight you on that. But, I've been, a lot of people say, well, you can never get like a methodology in there. I get it in there all the time, especially for kids on the autism spectrum and ABA. Get it all the time because, it's research supported. But getting back to yours, I also get into the IEP that a child should be in small classes throughout the day, or minimize transitions, be an environment that has reduced distractions. Well, reduced distractions mean just there, you're talking about smaller environment, because the more people you have, the more distractions there are. So you got to be, I mean, the supplementary aids and services section is limited only by your creativity. The more you think about it, the more creative you are, you talk to more people, you just try and come up with as many ideas as you can to tighten up that IEP as much as you can, to hold them accountable. Because that section of the IEP, the supplementary aids and services, they're just as accountable for ensuring that that's all done as they are for achieving the goals and the objectives and providing the services that are on the services page at section 5. Okay, good.
I know we gotta go on to 4, I know.
Yeah, we'll.
No, 3 for a minute.
Oh wow, we're only on 3, huh? Okay.
Yeah, 7 more to go.
Halfway through.
I have a question. I had went to a central IEP with a parent.
Uh-huh.
It was like a while.
Yeah. Well, yeah, the thing is, it's a tough situation. I'll tell you why. Again, it goes back to some court decisions that really are not pro-parent. But, and this was another case that came out of Maryland, went up to the Fourth Circuit Court of Appeals. And what the court said in that case was that the school system, if the school system gets to pick the school, if it's appropriate for the child, it's ultimately the school system's call, decision. But here's how I deal with that. When I go in with a parent, we want a particular school, and we're thinking they might suggest another school, I do my research beforehand and figure out what's wrong with this other school. Why will this other school not work for this child? And before we even get to that discussion, then we start talking about, well, here are all the things that the child needs, X, Y, Z, and guess what? They don't have it at this other school. So that's one way of doing it. Another way of doing it is saying, well, look, this other school, and again, you want to find out all the things about that school that will not work for this child. Try and find that out in advance. But what I often say too is, can we at least make referrals to both, just in case he's not accepted at that school, or just in case that school's full, or just in case there's going to be a delay in getting him there, because he can't be sitting not having an educational program, and he can't stay where he is because that one's not appropriate. You wouldn't be there in that central IP meeting if the current program was appropriate. And they may say, well, yeah, but if we'll send out 2 referrals, but if the other one accepts him, that's where he has to go. You just don't go to that one. you contact your favorite school. You say, okay, you're going to be getting a referral. We would like to schedule an appointment right now to come in and see your school and go through the interview process. And as soon as that school accepts the child, you say, okay, he's accepted. That's what we're doing. You don't even bother going to the other one. So it's a way of kind of manipulating the system. I mean, the system wants to manipulate you. I just manipulate them right back. There's a lot of different ways you can get around that. Okay. So, parent input statement. How many of you really spend any time writing your parent input statement? Good for you, Flossie. Okay, we got a few people. It's really important to have a good parent input statement. Yeah, it's right at the end of the present levels, comes towards the end of the present levels. So, yeah. So and write it up. You should write something up before you even go. It is your statement. The school system cannot tell you what you can put in it, what you can't put in it. You could say that, Mr. Principal is a rotten, no good, terrible person. Can't use, profanity, but and you can put that in your parent input statement because it's your statement. I don't suggest doing that, but what I suggest doing is saying, Johnny comes home every day and has a meltdown. If these things are true, he has a meltdown. He is so stressed by school that for 2 hours after he's home, he's crying, he's weeping. It takes 2 hours, whatever, to slow him down, to calm him down. He throws things around, he screams at people, whatever. Or Susie. It takes me 3 hours every single night to help her with her homework, to complete her homework. Every single night. and she's only in the second grade, or it doesn't matter, even if she's in high school, every single night, you're documenting that something's wrong here. And if you don't document it, like I said, if you say it but you don't document it, it was never said. They never heard it, okay? Anything that is interfering with you, that's creating problems for your child. And even if they're saying, we don't see it at school, but Johnny's coming home and saying, every single day I'm being bullied. Every single day I'm being bullied by this kid or that kid. They call me names, they knock my books out of my hand, whatever. These are the kind of things you put in that parent input statement. Now, with regard to bullying, I just want to mention something else parenthetically. Every single school in Maryland is required to have bullying report forms, easily accessible to students and parents. And you can probably also find them online as well. And what I will tell you is if your child comes home and says, I was bullied today, you ask for that that bullying report form. You keep filling it out day after day after day. Why? Why are we doing that? Why? Documenting. We're documenting. We have documentation. Okay? If you need it later, it bolsters your case. The more evidence, documentation you have, the stronger you make your case. So you keep doing it. Even if the school does nothing, even if the school says it's not happening, he's making it up, I don't care. If he comes home and says, she comes home and says, I was bullied again today, you fill the form out. What happens to that form? They have to send it to the Maryland State Department of Education. The school doesn't want you filling it out because it ultimately reflects on the school and the school system. Because the Maryland State Department of Education is keeping data, of bullying throughout the state, in different schools. They report it. So if your school, has reported 3,000 incidents of bullying and they're all from your child, maybe they'll do something about it. Maybe they will, maybe they won't. But you're always thinking about trying to build your case, and the best way you do that is with documentation. I'm going to move through this a little more quickly since we're starting to run out of time. Go ahead, sure. I don't want to cut anybody off.
The parent input statement. Can that be changed? Does that have to begin prior to the initial IEP?
Oh, no, you change it anytime you have an IEP meeting, or you can...
Like I have a parent that's just in the very beginnings of the process.
Right.
So they need to be right on top of that before the first IEP?
I would say so, or they could go to the IEP meeting and say, I'm going to submit my parent input statement later. I'll send it to you by email, and please put it in this section. They could do that. I've had that happen.
Ever before is in here.
Yeah. Well, once again, it's your statement. So you can say, this is not an accurate reflection of my parent input. So I'm going to send you, an email, and I want you to add this in. Okay. And they're required to do it.
And that's a living thing that can
Yeah.
change.
Yeah. Now, if you're in Baltimore City, they're just crazy people there. Okay. Well, good.
Crazy there.
It's pretty crazy there. Anyhow, I won't go any further with that. But in Baltimore City, they don't even put parent comments in it. They put all their own comments in. They'll say, well, this, we think this happened and this happened. It's just crazy. I don't know. But it's the section is for the parents, not for the school. So it's usually not something worth going to a due process hearing over. But I have raised it in one case, and even though we won that case, the judge just basically ignored that issue. She didn't say anything about it. I represented a boy years ago who was high functioning autism, very bright kid, but he had a lot of the autism spectrum disorder behaviors, and one of the things, he could be very, very easily provoked. And a kid in the school, and don't even ask me to explain this, but another kid in the school figured out that if he said to him purple socks, it would set him off. Don't ask me what that referred to because I have no idea. But say purple socks and it would set him off. And he would just start screaming and cursing at the other kid. And the principal tried to say the same thing. Well, it's his fault. All the kid said was purple socks. There's no reason for him to act this way. And, when we went in, I had the kid's therapist and everybody talk about, this kid is bullying him by saying purple socks. Obviously, it doesn't have any meaning to the rest of us. You can say purple socks or pink socks or whatever. It's not going to mean anything to us, but it had meaning to him. And this other kid figured it out, and just every time he saw him, purple socks. And this kid could not ignore it. So, if someone else is invading somebody's space and they know that, especially if they're doing it deliberately, and they know that it's that it's upsetting to them, it's also what we would call disability-based bullying, okay? Because the reason it's disability-based is because they're taking advantage of the fact that they know this person has a disability and using that disability against them. Just like saying purple socks to that boy that I was talking about, that was disability-based abuse, and then when you say it to the school that my child is being abused because my child has a disability and his disability is being used as a means to abuse him, then the school has been put on notice that they could be sued for monetary damages. Okay, and it could be big, and it has happened. Go ahead. I hear what you're saying. I think the thing to keep in mind is this, is if you think that other kids are doing things that they know, and they're doing it deliberately, that they know will upset her, incite her, whatever, because they know it's a part of her disability, you want to be able to use that language. This is disability-based abuse, or bullying, okay? So the next thing I wanted to talk about was the impact statement. A lot of people don't even know what the impact statement is. But as I wrote here, the impact statement comes at the very end of the present levels of academic achievement and functional performance. And it's presented in the form of a question. How does the student's disability affect his/her involvement in the general education curriculum? Most people don't pay a lot of attention to this, but this is a really important section of the IEP, because what you want to be able to do here is really hit all of the areas where your child's disability is impacting his or her education. So if your child has a reading disability, well, that's impacting it. But what if it's other things like sensory, okay? That the noise in the school, or maybe it's attention, that there's so many distractions in the school. Or maybe it's that they have difficulty maintaining their organization. How many of you had your child do his homework and forget to turn it in? That happens all the time, especially for kids who have ADHD. So these are all things that, and you don't just say that it's his ADHD or his organization. You say that it's impacting him because he doesn't turn in homework, and even though he's done it, he loses his schoolwork, he becomes disorganized, he gets bullied because he has some behaviors that other people find annoying or just take advantage of. I mean, you want to really beef that up, because that section will help increase the services that your child will get, okay? So it's a very, very strong section. I won a due process hearing one time just on the basis of how strong the impact statement was. The school system, it was Harford County, the school system was wanting to put the child in a program that we didn't think was appropriate, but the impact statement convinced the judge there's no way this child could be educated in this environment, when he has all these needs, and we were able to really emphasize that. Okay, so FAPE. Who knows what FAPE stands for? Go ahead. I can't even hear you. Free appropriate public education. FAPE, free appropriate public education. It is a legal term, which means that it is what the IDEA is all about. If the school system is not providing a child a FAPE, then they're not doing their job, and you can take action against them. So when I go to a due process hearing, I say, my opening statement is, Your Honor, the school has failed to offer my client a free appropriate public education, a FAPE. That's how I start, because that's the standard. School systems have to provide FAPE. From the very beginning of this law, it's always been about FAPE. The vehicle that provides FAPE, and I said this earlier, is the IEP. So when I am in a hearing before a judge, I'm saying to the judge, the IEP fails to provide my client a free appropriate public education. Okay, see how it's all tied together. So when I'm going to go to a hearing, one of the things I'm doing mostly is attacking that IEP, the appropriateness of that IEP. Or maybe the IEP is appropriate and they're just not implementing the IEP. They're not doing what they're supposed to do. But usually it's the appropriateness of the IEP. This statement up here, that the legal standard for a FAPE is an IEP that is reasonably calculated to enable the child to make progress appropriate in light of the child's circumstances. Now that was a decision out of the Supreme Court. It's in your document there. It's called Andrew F. versus Douglas County School District. And for 35 years before Andrew F. was decided, and Andrew F. was decided just a little over 2 years ago, back in 2017. For 35 years, school systems were operating under a standard that was merely more than de minimis. De minimis, just a Latin term, meaning just barely above the minimum. If a child made a little bit of progress, that's all that was required of a child with a disability. Is that what schools say about kids who don't have disabilities? We only want your child to make merely more than de minimis progress. Our goal is to make sure every child in Harford County makes merely more than de minimis progress. They don't say that. They say the exact opposite. Our goal is to ensure that all children make maximum progress, well, except for kids with disabilities. Because that was the standard for 35 years until the Supreme Court entered this decision in Andrew F. and said, here's the new standard. And they said it's markedly, that's their term, markedly higher than the old standard. Markedly higher. So if your child has been in the school system with an IEP for more than 2 years, well, those years, more than 2 years ago, they were operating under the old standard. Now they have to operate under the new standard. Have they made that transition? No. Schools are still very often operating under the old standard because they don't really understand the difference. Honestly, your regular classroom teacher, your special ed teacher, even some of the special ed supervisors do not get that this is such a higher standard that they have to be doing more. So it's our job, as advocates and parents, to hold them to a higher standard. So every time you go to your IEP meeting, you want to think in terms of, okay, what does this really mean? Appropriate in light of the child's circumstances. To me, it means, what is the child capable of? Let's look at what this child's abilities are. And let's make sure that this child is achieving at the level that's appropriate in light of his or her circumstances. So it's a higher standard. It used to be before, we're not talking about potential. We're not talking about what they're capable of. We're talking about just making a little progress beyond what they did the year before. Now, it has to be higher. Go ahead. I knew there'd be questions about that. The only relation between discipline and FAPE is if a child who has an IEP is put out of school for more than 10 days. They're still required, the school's still required to provide a FAPE, meaning free appropriate public education, which means they still have to implement the IEP. So that's the only relation to discipline. And the only way a child with an IEP who can be put out of school for more than 10 days is if the behavior was not related to the child's disability. So that manifestation IEP meeting, everybody know what we're talking about, manifestation, I mean, basically if your child is going to be, if you get a notice from the principal that your child is being recommended for suspension for more than 10 days, they have to hold an IEP meeting to determine whether the behavior for which your child is being disciplined is a manifestation of his disability. If it is a manifestation of his disability, he can't be put out for more than 10 days. If it's not a manifestation of his disability, they can, but they still have to provide a free appropriate public education. So either he's on home instruction during that time, or he's in an alternative school. And the only time that they can go beyond the 10 days is, and when it is a manifestation, is if the child brought a weapon to school, drugs, or seriously injured somebody. So those are the only exceptions here. Okay, so this is important to know. It's important, to recognize that school systems are held to this legal standard. It's not a really easy standard to understand, but I think if you think of it more in terms of, I know my child is capable of doing X, Y, Z, and I want my child moving towards that. Even if it's just this year, my child's reading at the 3rd grade level, but I know with the proper instruction he can be reading at the 5th grade level by the end of the year. Are they offering that? If they're not, then maybe they're not providing your child a FAPE. So an IEE, Independent Educational Evaluation, can be, a psychological evaluation. It can be a neuropsychological evaluation. It can be speech language, occupational therapy, physical therapy, functional behavioral assessment, music therapy, whatever. And the way it works, they've done an evaluation of your child. Let's say a psychological evaluation. You think that this psychological evaluation is not appropriate. They didn't do it right, or the results are just so far off that something's wrong. You say, I would like an independent educational evaluation. That's all you have to say. You don't have to say anything else. The school system then has to, right then and there they don't have to say anything, but within 30 days they have to tell you that they're either going to file for a due process hearing, or you can go ahead and get your independent evaluation and they will pay for it. So I've gotten lots of neuropsychologicals, which typically cost anywhere from $2,500 to $3,500. School systems paid for. Yeah. I mean, what I would tell you is that most of the time, school systems will not fight it. They will not go to a due process hearing, but sometimes they do. And I did have a case 2 years ago, about a year and a half ago, where Anne Arundel County Public Schools spent $35,000 paying a private attorney to fight a parent so that they wouldn't have to pay for a $2,500 psychological evaluation. It is stupid. It doesn't make sense. But that was that school system wanting to send a message to that parent and other parents in Anne Arundel County that we're just going to fight with you. Yeah. Here's what happens. You're unhappy with the evaluation. You ask for an independent evaluation. So, it's not a big risk. And if they say, we're going to take you to due process, you can withdraw your request, okay? If you don't want to go to due process. Now, if you want to go to due process, call me up and we'll talk about it. but because, and the reason I say that is because in the last 5 years, parents who have tried to represent themselves in a due process hearing have not won a single case in the last 5 years in Maryland. So winning what we call pro se without an attorney is not likely, in the state of Maryland. It's very difficult. So a lot of times I hear from parents that, they say, well, my child is passing this class or that class, and therefore he doesn't need an IEP, or he doesn't need goals in this area. Grades are not the final determinant of whether a child needs an IEP, okay? So, a child could be very, very bright and might even be on grade level, but still needs academic and specialized instruction in certain areas because they're not where they should be. So you have a child who should be functioning maybe 2 grade levels above grade level because he's got an IQ of 130, but he's reading right at grade level or maybe a little below, and they say, well, he doesn't need specialized instruction for that. Yes, he does, because it's what you call twice exceptional. He's very bright, but he also has a learning disability, if it's been documented, a learning disability that's impacting his ability to benefit from the instruction. Okay, so a lot of times, people will say, well, there's no adverse educational impact. There is an adverse educational impact if the child is not functioning at a level that is appropriate in light of his circumstances. And that's where we keep going back to that definition of FAPE, or the standard for FAPE, Is he making progress appropriate in light of his circumstances? And if he's functioning below where you would expect him to function given his cognitive ability, then he's not working at the level that is appropriate in light of his circumstances. I've only got about 5 minutes, so I just have a couple more to do. I know a lot of times people will say, well, we can't put this in the IEP. If we put it in the IEP, then your child has to come off of the diploma track because your child's in high school and we can't do independent living skills, or we can't work on employment skills because that's not a part of the curriculum, and the curriculum takes precedence over the IEP. It doesn't. It doesn't. And if the child, I mean, sometimes it has to be a decision for the child and the parent to decide, okay, yeah, there's only so many hours in a day and maybe you can't get all the credits you need in order to graduate on time, but in order to get, the skills that you need to be independent, to be able to get a job, maybe you need to stay an extra year, and there's nothing wrong with that. I mean, a lot of kids do it. Just ask my son, who's now in his 5th year of college, and God knows if he's ever going to graduate. But it's the curriculum does not outweigh the needs of the child. And when I say the needs of the child, what that IEP should cover for that child. And finally, number 10, Maryland has passed some regulations that are a little bit better than or go beyond what the federal government says. We talked before about Maryland specifically says that there has to be, you have to receive 10 days notice before an IEP meeting. So that's required under Maryland law. That's not in the federal law. Some states don't have that, but they just, but you still have to do it within, give people enough time so they can be there. Other things, Maryland is very unique in this. We're the only state, I believe, that requires a school to give parents any document that's going to be discussed during the IEP meeting 5 business days prior to that meeting. If you don't receive the documents, if you go to your IEP meeting and they pull out a document that you haven't seen before, you can stop them from even discussing that IEP, that document. They pull out an evaluation, they pull out even a teacher report. You haven't seen it, whether it's a progress report or an anecdotal report. Any piece of paper they pull out that you haven't seen, you could, and you don't have to, but you do have the power there to say, we're not going to discuss that because I did not receive this 5 business days prior to my child's IEP meeting. We'll come back another time. Problem is it inconveniences you a bit, but but it sends them a message. Maryland also now requires that there be parent consent before the school can move your child from a diploma track to a certificate track, or even put your child on a certificate track to begin with, okay? It needs parent consent. And they also need parent consent in order to put in the IEP that a school is allowed to use restraint or seclusion with your child, okay? So those were things that, some advocacy groups really advocated for, because before schools were just saying, yeah, we're going to change your child to a certificate track, sorry, and if you don't like it, you can take us to a due process hearing, and then you'll have the burden of proving that he should be on a diploma track. So go ahead.
Do that in the 3rd grade. I don't know how that's.
Well, sometimes they want to do that. Sometimes they want to say even in the 3rd grade.
Shocked when they asked me.
Oh, they did. Oh, they did.
Oh, yeah.
They told you that they were putting him on a certificate
Correct.
track? Now, was this recent?
Well, she's in 5th now, so yeah.
Is she still on a certificate track?
Yes.
Do you want her on a diploma
I
track?
think- No, I don't think at this point that she could, but I certainly didn't know that in the 3rd grade.
She still could. She still could. The only time it gets really important is high school. But even middle school, you want to have those foundation
I was
skills
quite
building.
shocked in the 3rd
Yeah.
grade and making me decide whether my child's going to get a diploma or something.
Well, every year you have to sign that parent consent saying that she's going to be on a. They're supposed to do it every year. Every year that's a question. It's not, you don't do it one time. You don't sign off one time and say, yes, my child can be on a certificate track and they don't have to do it anymore. It has to be every year. Same with the seclusion and the restraint. Every year, they have to ask you, do you consent to this? And if they're not doing that, then they're breaking the law. Okay? Well, if they want to move your child to a certificate track, they have to ask, they have to get consent. So if it's not even a question, I mean, You know, they may never ask you because your child's just going to stay on a diploma track. But if your child is currently on a certificate track, they have to say, do we have consent for her or him to remain on the certificate track? And it has to be signed. There's a form they have that that has to be signed by the parent. Not happening, huh?
No.
That's interesting. Yeah.
Which I didn't know,
If there are behaviors that are interfering with the child's educational progress,
and there are.
then they should be doing an FBA.
And they
Yeah.
said no to that.
Yeah, yeah. And so if it's a clear no,
It was a clear no.
what parents can do, there's a couple things they can do. They can go and get an independent FBA. And independent FBAs, you can't do an FBA in isolation. Somebody has to come into the school and do observations because it's data collection, it's doing actual observations. So you can get and there are people who do independent FBAs and do some that are very good. And then submit it to the school and then submit the bill to the school too. Because if you've asked for an evaluation and they refuse to give it to you, then that's a reason for getting an independent. And you don't even have to ask them in advance. You know, you don't have to tell them in advance you're going to get it done and you want them to pay for it. You just go ahead and do it. And then you give them the FBA and then they review it. And then if they say, yeah, okay, we've got an FBA here and now we need to develop a behavior intervention plan because there are behaviors that are interfering with education. So, you know, now you have an evaluation that they've accepted and that they should have done but didn't do. You've got them. And to get them to pay for it would probably be nothing more than filing a state complaint if they said no, which they probably would say no. When you say, here's the bill, they probably would say, we're not paying this. Then you file a state complaint. And I think the state would make them pay for it.
Like the law is written.
Yes, it does. And this is where school systems, I was saying before, they haven't caught up with the new standard for FAPE. So she's still operating under the old standard. She's not looking at it in terms of appropriate in light of your child's circumstances. Okay, so your child, you know, I'm just going to say hypothetically, you know, because your child may be capable of functioning several grade levels above grade level, but he or she's only functioning at or slightly below grade level. And they say, well, that's not a disability then. It is a disability because of the new standard, okay? So, I guess what I would say about that, you're going about it the right way in identifying the areas where your child needs specially designed instruction. And the more specific you can be with that, the better. But you might want to consider an independent evaluation, either one that you get yourself or one that you ask them to pay for. I typically would not get too hung up on what you call a plan if it's a good plan for the child. But I do get a little hung up on calling it a 504 instead of an IEP, and here's why. Schools notoriously ignore 504 plans. Every 504 plan I've ever seen, the school has ignored. I have a case right now that is pending a due process hearing in Baltimore County. And the reason they get ignored is because it's the general education teacher who's responsible for the 504 plan. They don't get that additional training that a special education teacher gets. They don't get the additional time. They don't get the additional resources or the supports. So general education teachers have these big classes to begin with. They're already tapped out and they're asked to do something more. So in this case that I have in Baltimore County, it's a boy in high school, and the teachers flat out refused to do the 504 plan. They've come right out and said, I'm not going to do it because I don't have time to do it. I don't have the ability to do it. You're stretching me too thin as it is. I can't do it. So why would you even go to a due process hearing when the teacher's saying, I can't do it? Even if you win, this teacher's still not going to do it? Here's why I'm doing it. Because I want an order from the judge ordering the school system, ordering the central office to give that school more resources so that they can do it. This isn't a matter of just people not wanting to do the job, because I think these teachers are actually pretty good people. They can't do it. They're being asked to do too much. So I'm trying to help them get more resources. So as long as they keep saying, yeah, we know we know the 504 plan is there, but we're not following it, they're really helping build my case, and I'm helping them build their case to get more resources. But anyhow, 504, and I'll just give you one real short anecdotal. I had a case in Calvert County, I don't know, 5-6 years ago, where they did the same sort of thing as they're doing with you. They didn't want to give an IEP, but they would give a 504, and they were putting everything into that IEP that we wanted for an IEP, into that 504 that we wanted on the IEP, everything. And so I couldn't exactly argue that what they were giving us was inappropriate when it was exactly what we were asking for, just they were calling it a 504 instead of an IEP. The director of special education was sitting in the room, and I said to her, you know, I like the plan, the problem is you're calling it a 504. And my experience with 504 is that they get ignored. And she says, well, you know, that's true. She admitted it to her credit. That's true, but I'm going to make sure that this one is not ignored. And I'm going to make sure that everything that's in this 504 gets done the way it needs to be done. And it says, and if it doesn't, she says, if it doesn't, you come back and we'll give them an IEP. It didn't happen. Even with the director of the whole county of special education saying, and the reason was, she's a special educator. She's in special ed. She's not in general ed. She had no authority over those general education teachers. She could talk to them till she's blue in the face saying, you got to do this, and they'll just say, yeah. So that's why I'm not a fan of 504, because it just gets ignored.
Where do you begin?
Yeah, that's a tougher one, you know, because like I said earlier, the state doesn't look at they look at the procedures. Did the school follow the procedures? They don't look at the substantive effect. So the substantive being, is this child eligible for a 504, or an IEP? They're going to look at, well, did they do the right procedures? Did they do an evaluation? Did they have an IEP meeting? Did the parents attend? Did they discuss everything? Did they have an open mind? And if they did all that and they came to the conclusion the child doesn't need an IEP, the state is not going to reverse that with a state complaint. The only way you reverse that is in front of a judge, a due process hearing. So that's more of a challenge. Did you have another question?
Yeah.
Well, you could, if he needed that, even if he had, let's say you don't have an IEP but you have a 504, if he needed it in order to access his education, then they'd have to provide it, okay? Because that's as much of an accommodation as it is a direct service. But if you had the IEP, it gets a little stronger, like I said. So yeah, if you don't have 504 or IEP, you don't have any claim to that, to access those devices. So, and I just want to mention, I think independent evaluations, private evaluations, usually are better than what the school system does. Especially if you get a neuropsychological. For a child who is 2E, twice exceptional, that's going to be more detailed and discreet than what the school system's going to do.
Do you find that
They'll shut it down if you just present them with the let's say this private neuropsychological, here it is, they'll shut it down. I mean, they'll read it, and then they'll say, well, that's very interesting, but, Dr. Freud, he's, what does he know? But what I do when I have a client who has an independent evaluation is we bring the person who did the evaluation to the table, because they can't just thumb their nose at that person. I mean, I've had parents come in and say, I gave them my private neuropsychological, and they started asking me all these questions about it. They said, well, why did he do this test? How come he didn't do this test? They don't know. Parents don't know. I couldn't answer that question either. But the person who did the evaluation could, and that shuts them down. And even though it doesn't guarantee that they will accept the recommendations, they have to explain why. If they agree with all the assessments, which they almost always do, but then they don't want to agree or accept the recommendations, why? How, if this leads to this conclusion, how can you then say no to that conclusion? So, well, that all comes down to the drafting of the 504 plan. You got to make sure, if the 504 plan says that upon request the student will receive X, Y, Z, but if it doesn't say that, then no, the student is not required to ask for it. And that's one of the things that I've heard a lot. This case I was talking about in Baltimore County, some of the teachers say, well, he never asked for it. He never asked for this. He doesn't have to. You're supposed to be providing it. So, yeah.
So what do you do?
Well,
I mean, what does a parent do?
yeah. The problem with 504 is that you can't file a state complaint for 504 because the state only enforces IDEA violations, not 504 violations. So your complaint has to go to the Office of Civil Rights, which is a branch of the U.S. Department of Education. Does anybody know who the Secretary of Education is? Do you think anything's going to get done with the Secretary? I mean, people are trying, and the complaints that go to OCR, Office of Civil Rights, are just sitting on somebody's desk somewhere because not much is being done these days. So it's very hard to do anything about it. What I will tell you about 504 that a lot of people don't know, especially teachers and a lot of school personnel, is that violation of, okay, if a school system denies a child FAPE, a free appropriate public education, you are entitled to compensatory educational services. You can't sue them for money though, but you can sue them to make up for the services that your child was denied through their not providing your child a FAPE, or maybe even sue to get a private placement, whether it's a Kennedy Krieger or Harbor School or any one of a dozen of the private schools around here. 504, you can sue for money. You violated my child's 504, which is what we're doing in my Baltimore County case, and we want money. Because with 504, now you can sue for money if the 504 is an anti-discrimination statute, okay? It prohibits disability-based discrimination. I was talking before about disability-based bullying. That's a form of disability-based discrimination, okay? So you can sue for disability-based discrimination under 504. The standard for proving that case, for getting money, is pretty high. You have to prove that it was either due to gross negligence or deliberate discrimination. Deliberate discrimination would be a teacher saying, I'm not going to implement this 504. Thank you, teachers, because the case I have, they've come right out and said that, and I'm thanking them. We can sue for money, under 504. And if there's any kind of retaliation, you can sue for retaliation, such as if the school gets angry because you're pushing too hard, and they decide they're going to retaliate, like Flossie when they were taking away your child's services and that sort of thing. There's a great discrimination case right there. It's a discrimination suit. There have been some really famous, well, I don't say famous from my perspective, discrimination suits on disability-based discrimination suits. There was one out in Portland where where a teacher actually sued because she got fired because she was advocating for the children who she was working with. She was an adaptive physical education teacher, and by all accounts she was very, very good and very dedicated to her children, more dedicated to her children than the school administration was. And so she kept writing to them and saying, we're violating these children's rights because we're not giving them this, and they need this, and they need this, and you won't give it to them. And they told her, stop writing us letters. We don't want to hear about it. Just do what you can with what you have. And when you're a PE teacher, you need certain resources and certain equipment, and they wouldn't give her anything. They wouldn't even let her use the gymnasium. They said you can't use the gym because the non-disabled children are in the gym and you can't be in there when they're in there. So she couldn't even use the gym. PE teacher can't use the gym. So she wouldn't stop writing, and they eventually fired her. So she sued them, and she won because it was retaliation based on her advocacy. She didn't have a disability, but she was advocating, and based on her advocacy, because of her advocacy, they fired her, and she won a $1 million judgment against the school system. Plus, even better, they had to pay for her attorney's fees, which were over $600,000, which is my favorite part. So So there are some, some pretty significant cases out there. They're very hard to win. So, but I would say that, when I don't understand why schools, I do and I don't, why schools ignore 504s, because a lot of times it's just the general ed teacher, and the general ed teacher really doesn't have the resources that they need to be able to do it. But it's because the central office people are not giving it to them. So, sort of went off on a tangent there. I apologize for that. Yeah. Okay. So the question has to do with behavior in a child who is being put in a seclusion room. And in the seclusion room, it seems like the behaviors become even more escalated, and then the school wants to punish, if you will, the child more for engaging in destructive behavior while in the seclusion room. Is this a private school or a public school? It is a private school. Kennedy Krieger? Yeah. I think they need to do a functional behavioral assessment. I think you also need to consider whether or not that is the appropriate placement for him, because if that just seems like a situation where it just keeps getting worse. They're making it worse. And look, I think Kennedy Krieger is pretty good in a lot of regards, but they're not perfect. And there may be another placement that you might want to consider. There are other programs. There are some schools out there that I think are really, really great, but none of them are perfect. And they make mistakes. And look, I worked at the Forbush School, which is a school for kids with emotional disabilities, for close to 20 years. And when I look back at how we did things, I recognize we were making a lot of mistakes back then. And so sometimes it takes, you have to get away from the situation to be able to get a better view of it. Because when I was in the middle of it, and I was one of the ones who was in charge of the behavioral intervention program, I thought I was great. I thought we were doing a wonderful job. But afterwards, I looked at it and said, and when I learned more about how other people did other things, I realized that we made a lot of mistakes. So, I think you have to, just, it's not, you don't have to accept what's happening. You can say, we need to keep looking at this. And whether it's a functional behavioral assessment or
discuss it,
yeah,
warrants a discussion.
Absolutely, yeah.
Are they allowed to go back? Is there like a certain statute of limitation?
There is a 2-year statute of limitations, but the way the statute is written, it says 2 years. You have to file a due process complaint to challenge denial of FAPE or denial of whatever procedural violations within 2 years of the time that you knew or should have known of the violation. So it could be that you learned yesterday about a violation that took place 6 years ago. Okay, it's when you knew. So that means you have 2 years to file your due process complaint. Now, if you're filing a state complaint, it's 1 year from the violation. But what I would tell you about any kind of after-school activity, a program, a program or a child care program or something like that, that falls under the Department of Justice, believe it or not. Because that falls under the Americans with Disabilities Act. It's a whole other statute. So we could spend a few more hours on that, but teacher A, Flossie, could be the best teacher your child could ever possibly have. But Flossie just won the lottery, and she's decided to retire to Tahiti. And now, now your child has me, and I'm the big bad wolf, and I'm terrible for him. So it's very hard. One person can make all the difference in the world in a child's life, So and I'm a big believer in leadership. If you have a great principal, they can even, in many respects, overcome a bad teacher, because they'll do something about it. They'll make that teacher either shape up or ship out. So I've seen some really good principals make a difference in a child's life too. Thank you all for coming.
Thank you.
It's fun.
Thank you so much for
Sure.
presenting.
Sure.
Greatly appreciate